Thank you. I would just like to add a layer to the comments just immediately preceding and highlight that the joint partnership between the EU and Egypt is extremely alarming because torture in Egypt is systemic. And that's not to be confused with systematic, which Olivia will talk about briefly, but systemic. And what I mean is that it's deeply embedded in the structure and culture of Egypt's security apparatus, which is the exact apparatus that the EU agreement calls a pillar of stability and security in the region. And in truth, it's anything but. Torture is institutionalized through abusive practices that are perpetrated at every level of Egypt's criminal justice process. It's not about isolated incidents. It's not about rogue individuals. It's about ingrained behaviors that are standard operating procedures for Egyptian law enforcement, prosecutors, and judicial actors that together combine to maintain a system that tortures. I'll highlight this system using 3 examples. First, evidence obtained through torture is routinely introduced to secure convictions in Egyptian criminal trials. Notwithstanding that Article 55 of the Egyptian Constitution prohibits the use of such evidence, that mandate is in practice not honored. Instead, forced confessions are central to the criminal justice process, and Egypt's prosecutors collaborate hand in glove with security actors to base charges on false confessions obtained through problematic and violent methods of interrogation. Take, for example, the case of Father Isaiah, a Christian Coptic monk who was sentenced to death on the basis of torture-tainted evidence. Throughout trial, he was prohibited from seeing his family, he was prohibited from seeing his lawyer, and upon request of medical physical examination, he was denied and subjected to ridiculing comments about his name. And he was put to death in May 2021 on the basis of torture-tainted evidence. Second, the denial of medical care for detainees is a deliberate practice aimed at exasperating their suffering. These denials are not oversights. They are intentional acts of neglect to punish the spirit of detainees, to extract confessions, and enforce compliance. Even in medical emergencies, whether or not a person receives health care is at the discretion and whims of prison guards and other prison officials, who routinely deny or downplay the severity of detainees' health conditions and refuse to transfer them to outside treatment. For example, take the situation of a female prisoner who had kidney pain, and every single time she complained to authorities, she was either denied, not given an examination, and was just given painkillers. After several months of asking, she was finally seen by a physician who determined that she had uterine cancer, and ultimately her uterus had to be removed because the cancer evolved to such a progressive state. Finally, political prisoners are kept in a continuous loop of detention through a process called recycling or rotation, where after serving a sentence or obtaining a release order, prisoners are new charges are fabricated, justifying new cases and new periods of pretrial detention. This practice effectively extends imprisonment indefinitely, sidestepping legal limitations and manipulating the justice system to detain individuals without due process. By recycling cases, the authorities maintain control over political dissent, they suppress opposition, and they use the legal system as a tool of repression. For example, take another case from 2014 where a victim was arrested, disappeared for a week, only to be reappeared a few days later and held in remand for 3 years, at which point a judge ordered the victim's release. That victim was transferred from prison to a police station, disappeared for another week, and then held in remand for another 6 months, upon which they got another release, new charges, new remand for another 6 months, in which case they got another charge, another remand, and the cycle keeps going and going. This recycling, the denial of medical care, and the use of torture-tainted evidence are emblematic of Egypt's system of torture because they're rooted in bureaucratic and legal mechanisms that perpetuate abuse and control targeted individuals, ensuring their continued incarceration, silencing, and suffering. Far from a pillar of stability and security, these practices are symptomatic of an Egyptian regime that is absolutely confident in its impunity and its ability to maintain such systems. Its confidence in its impunity, its confidence that it can maintain these systems comes in part because of the complicity and erasure caused by agreements like the EU partnership agreement with Egypt. Today, I call on the international community to honor its obligation to respect, protect, and fulfill the right to be free from torture by making good on that promise and not continuing to enter into such agreements. Thank you.
Thank you very much, Mr. Grant.